Okay, good evening, everybody. We have 6 bills to hear and 4 bills that are up for consideration. Let's start off with Representative Canario's Bill 7688. This subjects persons who are in extreme risk to protective orders. We do have a substitute A on this bill. Mr. Canal, would you come up, counsel for the committee, and explain the sub-A changes to the committee, please?
Thank you, Chairperson Keeble, members of the committee. The key change, I'm going to address specifically the key changes from the original bill to the sub-A before you. The sub-A adds several definitions to clarify some of the terms of the bill, including law enforcement agency, law enforcement officer, and the definitions of one-year extreme risk protection order and temporary extreme risk protection order are put in the bill. From here on, I'm going to refer to them as a temporary order or a one-year order. There's been a definition added for social media. The reason for that is the bill adds that unlawful threatening or reckless use of brandishing a firearm by a respondent on social media is something that can be considered by a judge when deciding whether or not to issue an order under this chapter. Instead of having the petition be filed in the county where the petitioner resides, which is what the earlier bill, what the original bill said, now it has to be filed in the county where the respondent resides. It can only, this is a major change, the petition can only be filed for an extreme protection order by a law enforcement agency. It's no longer being done by the Attorney General's office to avoid any conflicts, and it's also being taken out any individuals. It is by the law enforcement agency. It specifically says a petitioner has to file a petition upon receipt of credible evidence. It has to be supported by a written affidavit sworn by the petitioner under oath. And if the petition is filed, the court may issue a temporary extreme risk protection order if they find there's probable cause. That's the same standard as before. The key language is that the respondent has to pose a significant danger of causing imminent personal injury to self or others. Again, that language was was somewhat in the original bill, but we've made it consistent, and that's consistent with California, Oregon, Connecticut, and Indiana. If the court does issue a temporary order, they'll schedule a hearing within 14 days of the issuance of that temporary order. With the temporary order, there is I'll wait a moment. Rephrase. With the temporary order, the court would also issue a search warrant. That's issued and executed pursuant to the provisions of Chapter 12.5, references, I should say that, which covers most warrants. The warrant would be for any firearms in the possession, custody, or control of the respondent. The notice language has also, the notice that's given to a respondent when the order is served on them has also been added to. One of the big changes is that the language is added, if a person believes they cannot afford an attorney, they refer to the public defender for an intake interview. That doesn't make this a criminal action, but it does give them that reference there to determine their financial eligibility. The grounds for issuing the order remain essentially the same, except that they can look at social media. That aspect was added. If the brandishing has been noted on social media, that can be considered. The standards of proof have not changed. Temporary orders issued under the probable cause, and then a one-year order and extensions are issued upon findings of clear and convincing evidence. The burden in those situations is on the petitioner. That is still the same. This is new. The courts will schedule a review hearing on the matter, and it has to be scheduled within 30 days before the date the one-year extreme risk protection order is set to expire. That's if the order is granted. The initial order, I'm sorry. After the temporary restraining order, then the hearing on the 1 year is heard. The grounds for the 1 year, again, are, as I said, the same for the temporary. If they grant a one-year order, they have to schedule a review hearing within the last 30 days before the calendar days before the order expires, so that the court has a chance to check in and see where the people are. A respondent can still ask for termination before that time. A petitioner can ask for renewal of the order within 14 calendar days before the order expires. There was some concern last time about some issues about if people are filing in bad faith. The penalties for giving false information or filing to harass someone have been increased. If you do that, the penalties now are up to 5 years imprisonment and a fine of $5,000. It was 1 year and $1,000. Service of all the orders is generally by the extremist protection orders by the petitioner, who's a law enforcement agency. Search warrant issued under Chapter 12-5. The Division of Sheriffs only becomes involved in the service of the 1-year protection orders once the weapons have already, if they've been taken, if there's possession of them. They can request the assistance of the state police if they want to. Constables are not employed for service in this chapter. They were referenced in the earlier versions, not now. The sub-A removes language about the court developing court forms information. The states which have these have forms in place. The courts can adopt those other forms. We don't usually have to put it in the statute that they develop these forms. They're all there. California in particular has an extensive set. All the documents that are filed with this, the petitions, the orders, the warrants, the affidavits, evidence, anything filed pursuant to this chapter now is expressly deemed confidential. It's not available for public inspection or disclosure absent a court order. That doesn't prohibit the entry of orders into appropriate databases, such as the National Instant Criminal Background Check System, NICS. That was already there, but the bill straightens up the confidentiality. The bill removes the amendment to 1147.5 regarding possession of firearms, and it adds some language into the warrant section. Lastly, the sub-A amends at the end. It amends section 12-5-2 to clarify that the warrant issued under this chapter, warrants issued under 12-5-2 include a warrant issued pursuant to this chapter, which is 8-8.3, the main chapter in the bill. It's a lot of material, but I believe that summarizes the main changes in the bill, Chair.
I'm sure the committee will have a lot of questions. Okay, so we have a sub-A in play on 7688.
Mr. Chairman, move passage of the sub-A to 7688 and indefinite postponement of the underlying bill.
Second.
Okay, we have a second from Vice Chairwoman McEntee and also the sponsor, Representative Canario. Okay, discussion. Let's start with Representative Filippi.
Thank you, Mr. Chairman. I'm not prepared to vote yes or no on this bill at this time. We've just gotten the sub-A. It's 13 pages. It's highly complex. I think that we should be holding this bill for further study and having another hearing where people can come in and offer their opinion on what this bill does. If you remember, last year we passed the Protect Rhode Island Families Act, and now this year the court system is asking us to fix it because there were errors in the bill that we passed. I think with this we should take a deep breath, have another hearing, let the ACLU come in. They raised, I think, 15 pages of concern in a memo about our prior iteration. We should have people from the Second Amendment community come in and they can offer us their opinions. The last thing I want to do is pass a bill that has errors in it, and we're going to have to come back next year and fix them, especially when it affects people's fundamental rights. I haven't had an opportunity to read this bill. It was just put in front of us, and it's 13 pages, and it's highly complex, and I just don't think we should be voting on it. Thank you.
Representative Knight.
I actually have a question about the bill. Can you just clarify for me, if once the order is issued and somebody, the respondent can move to vacate the order and they have the burden of proof if they do that, is there a time limit before or after the order issues when they can do that? What I'm concerned about is the question behind the question is the judge issues the order on, some Tuesday, and then a particularly disgruntled person just comes back at the next week and files for an order to vacate, and then the court is obligated to do the whole hearing again. Is there any time limits built into the bill about when you can bring a motion to vacate or terminate prior to the 1 year?
There's a limit on the. You can only do it once.
You can only do it once.
You can only do it
Okay,
once. I
great.
don't believe there's a time limit as to when you want to take your bite at the apple, but you can't. You might be able to force the court to do it the next week, but then you're done for your year.
Done for a year. Thank you, Mr. Chairman. I appreciate that. That's the answer to my question.
It's a one-time. Once the 1 year order is in place, for that 12-month period, you've got one time to do it. Yes.
And Mr. Chairman, if I can just offer for the record, I had the opportunity to review this bill in depth prior to coming into committee today, and I think it fixes a lot of the problems that were identified by the ACLU and some of the concerns that I had in our last hearing on this issue. I think this is a good bill, and I look forward to voting for it.
Okay, further, Vice Chair McEntee.
Thank you, Mr. Chairman. Bill, you referred to social media, and I couldn't really hear with the noise outside, so I see it in the definitions, but can you tell me where else it's used? I mean, many times we see in these mass shootings that there's something on social media that somebody overlooks, so I just wanted to see where that is in the amendment, in the sub-A.
Yes, Representative. Again, the definition, as you know, is in the definition section,
Right.
section alphabetically. Then the reference to it in the meat of the bill, if you will, is on page 5, lines 19 and 20. These are the things that the court can review in determining whether or not to issue these are the grounds for issuing an extreme risk protection order. And they include the unlawful threatening or reckless use or brandishing of a firearm by the respondent, including but not limited to such action taken or displayed through social media. And that's the reference.
Thank you.
Representative Price.
Thank you, Chairman. I think I'd have to agree with Representative Filippi on this. It's major changes. We haven't had time to look over this bill. We got many people out here that are interested in this, and I think that it would be better spent time if we postpone this and hold it for further study, and so that we can look it over, and so that all the different communities can have their input on. It's a huge bill, 14 pages, and only one of us, from what I understand, has had the opportunity to read it. And we're not getting input from any of the citizens, from the ACLU or anybody. So that's where I stand on it. I'm not ready to vote on it either.
Okay, Vice Chairwoman Agello.
Thank you, Mr. Chairman. Like Representative Knight, I took the opportunity to review the sub-A and want to thank everyone who worked on developing this sub-A for addressing many of my concerns originally when we heard the bill, and many of the concerns that were raised in the committee hearing. For instance, there was language in the original bill informing neighbors, family members, work colleagues of the respondent that they were deemed a danger and their guns were being taken away, or that this process was beginning. I thought that was hugely invasive of personal privacy and putting a person's life and future at risk in their relationships. I am very pleased that that's out of the bill now. I was also concerned that there was nothing in there regarding the respondent having a right to attorney. I was told, well, everybody has an attorney. This is a civil thing, not a criminal thing, so we don't necessarily have the public paying for an attorney if the individual can't afford it. I was still concerned. This is so potentially impactful to somebody that I really felt we had to guarantee provision for attorney. That piece that Mr. Connell spoke of with the public defender determining whether the person can afford a lawyer or not, and then provision of a lawyer if they can't, is again something the ACLU raised. I was very concerned about. That's been addressed. I think in 3 or 4 of the areas that I was concerned about after the hearing, Danica and her team have addressed them. I am very appreciative, and I will vote for the sub-A. Thank you.
Representative O'Grady.
Thank you, Chairman. One of the issues that was brought up during the hearing was actually brought up by Whip Filippi, was this idea of a burden of proof, so that when an action is first brought against a respondent, the burden of proof falls on the state to prove that that person is a danger to themselves or others prior to guns being seized. But then I think, as Whip Filippi pointed out, when you come to a 1-year renewal process, that burden shifts, at least under the original bill, and it is now the burden of the respondent to prove that they are no longer a danger. And I think there was talk during the committee hearing that perhaps that should be shifted so that the burden should be on the state after a year to prove that the person continues to be a danger. Do we know if that's been addressed in this sub-A?
Rep. O'Grady, the standard for the initial 14-day is probable cause, which is a very low standard. The standard for the 1 year is state has to prove clear and convincing. The standard, if the respondent chooses to challenge that during the year, shifts to the person to prove by clear and convincing that it was made in error. But at the 1 year mark, if the state seeks to continue it, they again must show by clear and convincing that the person still is someone that should not have weapons. So I'm not sure that I wouldn't want to misrepresent Representative Filippi's testimony but that shift that you're talking about has been changed. Thank you. The burden has been increased on the state. Whip Filippi.
Thank you, and I'm glad that has been changed. And I would just briefly like to respond to Vice Chair Agello's comments that she took the opportunity to review the bill, and I'm glad you were given that opportunity, and I'm glad Representative Knight was given that opportunity. I was never given that opportunity, and I don't know which members of this committee have been given the opportunity to review this bill prior to the hearing today. I haven't. I don't think that's proper for such a complex bill that deals with fundamental constitutional rights. And if some of us are going to be given the bill beforehand, I think all of us should be given the bill beforehand. So I still can't vote for this at this time. Thank you.
Understood. Any further comment? Yes, Representative Price.
The 5-year, $5,000, is that for if someone perjures themselves? If someone makes a false statement, a false accusation? Did you say 5?
Yeah, Representative.
The penalty for making a false accusation has been increased from 1 year or 1,000 in the original bill, misdemeanor, to a felony, 5 years in prison or $5,000 fine.
It's on page
In an attempt
11.
to deter false accusations.
Page 11.
Yeah, it's on page 11, lines 12 to 15, if someone wants a reference, for reference.
And who imposes that penalty? Is that automatically done by the Attorney General, or does the...
The act doesn't speak to that. That would be basically, this is all a civil, that would be a,
No, let me
I'm sorry, not
answer,
civil,
Bill.
that one.
The person would have to be charged by the Attorney General's office. They would have a trial. It's a crime. We're making it a crime, so you would have a trial on that. It doesn't happen automatically. The Attorney General doesn't get to put people in jail for 5 years.
Well, right. No, I meant by...
Thankfully.
Does it automatically start the process by the Attorney Generals if they're found?
Someone would have to make a determination, just like any crime, that a crime had taken place, that a false accusation had been made. That person would be charged with a crime and proceed through the regular criminal process.
And who pays for this? The attorney fees, or does the person that was accused have to retain an attorney to press this?
No,
issue?
it would be a criminal matter the state would prosecute.
Okay.
Whip Filippi.
And I would like to add to that, Chairman, that we have a statute in this state that provides civil liability for criminal conduct. So if the Attorney General, the way I'm reading this, doesn't charge someone with a crime, someone who's been injured by the crime of that person can still sue them in Superior Court under, I think it's in Title IX somewhere, civil liability for criminal conduct.
Yes, and I don't think in order to get at civil penalties, you actually have to have been charged with the crime. And also, the person could be subject to a slander suit or a libel suit or something along those lines as well. Might face civil liability for that. Representative Price.
Thanks. Thanks, Chairman. What if it's found that if the police department makes false accusations, if there's some sort of a problem between the police department and someone they're accusing?
That would be, there's nothing about this bill that would be any different than any other situation of police misconduct.
Okay.
Okay, is there any further discussion? All right, Madam Clerk, may we have a roll call vote, please? Yes.
First Vice Chairwoman Agello.
Yes.
Second Vice Chairwoman McEntee.
Yes.
Whip Edwards. Craven.
Yes.
Representative Coughlin.
Yes.
Representative Covesi.
Yes.
Representative Canario.
Yes.
Minority Leader Filippi.
Not voting.
Yeah.
Representative Knight.
Yes.
Representative Shanley.
Yes.
Representative Price.
I'm not going to vote also.
And Representative Wilkinson.
Yes.